giving opening remarks and, some form of reaction to yesterday's happenings in court. Let's come back to the studio to get more feedback from our lawyer here. That's Mr. Jide Ologun. And Segun Showumi used some words that I want you to react to in assessing the role of the eminent jurists yesterday, led by Justice Inyang Okoro. But then Segun Showumi spoke about, according to him, them not exercising their discretionary powers, and talking about them not possibly being brave enough to push the frontiers of jurisprudence. But then we heard the justices speak yesterday about the limitations on their own part, talking about this new evidence that the Atiku legal team, wanted to push forward. The Supreme Court spoke about the powers accorded to it under Section 22 of the Supreme Court Act, which said on a good day it had the powers, so to speak, to order the lower court to kind of, maybe vary the judgment. And if I could just read that section for some more clarity. Section 22 empowers the apex court to order from time to time the lower court to inquire into any question before judgment, which may include rehearing of a case. And, it also says that the law empowers the apex court to assume full jurisdiction over a case as if it was instituted at the apex court for the purpose of rehearing a matter or remitting it to the court below for the purpose of rehearing. But the court said it was not applicable in this case because time had since passed, even on the part of the lower court.
Fantastic pronouncement there. And let me say this. At the tribunal level, which is the appellate level, you had 5 justices. In the Supreme Court, 7 justices. So we are talking about 12 justices here. And if you look at Section 36 of the Nigerian Constitution 1999 as amended, it provides for fair hearing. So what has happened is that both the petitioners and the respondents, the appellants, they have been given the opportunity to present their case. And on the issue of the certificate, the Supreme Court is asking, when INEC published the form that disclosed all this in June 2022, what have you done between then and now? There was something I learned when in school, fantastic, that if you go into an examination, read the instructions clearly. If you are to answer 5 questions and you answer 2 sufficiently and you submit, and at the end of the day, you even forgot to write your exam number, then you now start shouting, the examiner doesn't like me. No! And as a lawyer, sincerely, I want to say that we need to give more. There are moments we advise our clients that you don't have a good case here. If you want to go to court, engage other lawyers. These things are clear. The rules are there. And how do you exercise discretion? In the best interest of justice. Who are the stakeholders seeking justice here? All the parties. If you look at Section 131 of the Evidence Act, it says that if you come to the court seeking some pronouncements and you are alluding to some facts, you have to prove your case. It is not the justices. They even said it. You had 21 days to file your petition, so you are coming at this. And basically, the Supreme Court is not a court of evidence where so you just discovered this. So I think I quite appreciate Mr. Showmi's brilliant submission about the future. You see, someone said, you win, you gain, you lose, you learn. And that is a principle in business. You see, and I have been saying, I will never be sensational or sentimental. Lawyers are not trained to be. So these things are there. And I'm again counseling. Please take the pain to read the submissions of these justices. The decisions of the tribunal were read for about 13 hours. I mean, it's still there. So these are issues. Then you now learn, okay, next time, what am I? If you are supposed to present yourself in a particular manner and you don't, who do you blame? For example, I've bought a ticket to fly to New York City from Lagos, and the flight is supposed to be 3 p.m. And I come to the airport at 3:30 shouting at everybody that, I have a ticket, I have paid for it, I paid in dollars. No, that's not the issue. And these are things that some ascribe as technicality. If your vehicle is a petrol engine, you don't say because diesel is liquid like petrol, you go and inject that vehicle with diesel. So these are issues. Right. Justice is for all. And you are to get justice. And on the final note on this point, let me ask this question. In the Bible, 2 children were brought before Solomon by 2 women, one alive, one dead. And the one who was making noise was the mother of the one that was dead. So imagine that their neighbors came with them, shouting, no. The king had to sit back to say, okay, now, how do I judge this matter? And with the wisdom God has given him, he now said, go ahead and do this. And he was able to make the right judgment. I will always doff my cap for the honorable justices in Nigeria. And please, let's go and read what they have pronounced upon. They've given, I said it, at the tribunal level, we had nothing less than 80 senior advocates of Nigeria. I know how diligent lawyers can be. You know what I mean? So, and if you put the experiences of these 80, apart from the other lawyers that were with them, lawyers together, we are talking of over 100 years of practice experience. So what could have been done should have been done. It's as simple as that.
But
that's my position.